Also, Mr. Heath Chamness, representing the state's present by Zoom. Court's probation officers present. All right, Mr. Chamness, what do we have here?
You're muted. Heath?
Also, Mr. Heath Chamness, representing the state's present by Zoom. Court's probation officers present. All right, Mr.
Heath can't hear.
Oh, come on. What is going on? Can you hear us?
Is he muted on our
Are
side?
you? No. Okay. Let me see. Marcella, can you hear us?
Nope.
Yes.
Dawn?
Yes.
Heath, let's try you again.
Okay, I can hear background noise now.
Okay.
Well, we'll try it again. I don't know who all we've got right now, but it's calls number 241-1084-20, State versus Johnny Lee Evans Sr., who is present from the jail on Zoom on an indictment charge of possession of controlled substance with 2 enhancement paragraphs. Defendant's present, his attorney, Mr. Don Davidson. Court appointed is present by Zoom. State's counsel, Mr. Heath Chamness, is present by Zoom. Court's probation officer, Mr. Sproul, is present by Zoom. All right, Mr. Chamness, go ahead.
Your Honor, this is just I think this is just our standard pretrial hearing. I had filed my pretrial motions back some time ago. The last time we had a hearing, Mr. Davidson had a copy of those. There's really only one issue that I think that I need to bring to the court's attention. And it's an issue that Mr. Davidson and I have already talked about. It's an issue that the court's dealt with numerous times. During the investigation on this case, and this would go towards the in limine motion. During the investigation into this case, the officer ran the defendant's name before he searched the defendant or searched the car. During the running of Mr. Evans's identification, he determined that he had a blue warrant. So he was actually taken into custody before any of the alleged narcotics were found in the vehicle, which he was the only occupant of. So the only really issue that I want to clarify with the court is pursuant to what has happened obviously in this court, but also the case law, the arrest based on the outstanding blue warrant, I believe to be contextual to explaining why the defendant was placed into custody before he himself was searched or before the vehicle was searched. I have discussed this issue with the officer who made the arrest. We're not going to go into what he was on parole for. We're not going to go into how long he had a violation. We're not going to go into what the violation was even for, just that he did have an outstanding blue warrant and he was arrested on that warrant, and then subject to the search after the arrest, there was alleged narcotics that were found, which is what this case here is for. Outside of that, I'm not aware of any pretrial motions. I just would like to go ahead and get a ruling on whether or not we're going to be able to go into that. Because I think it's contextual and I think it explains to the jury why he was under arrest before they even searched him or searched the vehicle.
Oh, well, I take it Mr. Davidson had, I believe you mentioned it, Mr. Davidson has a motion in limine filed on that. So that's basically what the court would be ruling on, the motion in limine filed by Mr. Davidson. I'll let him say what he wants to say on the record, but I take it, Mr. Davidson, you filed a motion to in limine, seeking an order from the court prohibiting Mr. Chamness, from going into what he just laid out. He is requesting to go into, it says he has authority for it, so go ahead.
Judge, I am going to file my standard pretrial motions, and that will be one of the standard pretrial motions is the motion in limine. And so, yes, that's correct. It would fall under that motion, which I should be able to file sometime later today. But let me just respond. I think, and Mr. Chamness and I have talked about this. I think there's the solution that I would propose to the court is that instead of designating the existing warrant as a blue warrant, that it just be that the jury be told it's just a warrant and not specify what kind of warrant it is. And for a number of reasons, I think that would be appropriate. Not the least of which is that we would not need to voir dire on what a blue warrant is and what that means. I think if the jury is told on guilt innocence that there's just a warrant that's there without specifying that it's a blue warrant for a parole for an alleged parole violation, then I think it makes the record cleaner. It creates less prejudice against the defendant, and I think it would be a better solution to this. And I think that's what we're asking the court for a ruling for, is whether I understand contextually they get to say that he was arrested because there was an outstanding warrant. That I understand is something we can't contest. We're not contesting. What we are contesting is labeling it as a blue warrant or saying that it's a parole warrant when it would give the jury enough, the officer could testify to what he needed to testify to, that there was a warrant, and that's why Mr. Evans was arrested. And I think to go further than that would violate his privilege against self-incrimination.
All right, Mr. Davidson, do either you or Mr. Chamness have case law to present for the court?
Well, Your Honor, I have some that I can bring down to the court.
Well, that's actually what I'm talking about. In other words, that would be the court's request, considering Mr. Davidson's argument on his motion in limine. Court understands what Mr. Davidson is agreeable to and what he's not agreeable to. So if you can bring Mr. Chamness some case law down to the court on the issue, as well as Mr. Davidson, just bring it down to the office where the court can review it.
And Your Honor, in fairness to Mr. Davidson, if he's not objecting to the officer saying that he had an outstanding warrant and not calling it a blue warrant or a parole violation, I don't have a problem with that. If the jury's going to connect the dots, in all fairness, I mean, this is a less than a gram methamphetamine case that's enhanced to 2 to 20. So if the jury is going to connect the dots in their own mind, they're going to connect it when we voir dire on the punishment range. But I don't have a problem telling the officers to just say it was an outstanding warrant as opposed to a blue warrant.
All right, okay, Mr. Chamness, I understand your position, Mr. Davis. And I know you'll do this, being an excellent prosecutor. Just be sure the officer understands when he's testifying that the court's ruling is he can, as he should be able to. Obviously, his statement has got to be able to explain the reason, the basis for the search, which is the outstanding blue warrant. And if with Mr. Chamness' agreement, and I think that's correct, that's what I was sitting here thinking, that the motion in limine would only be granted from the standpoint that the officer can testify that the defendant had an outstanding warrant for his arrest without going into a blue warrant, which then you would have to explain probably what a blue warrant is. And so that would be that would be the court's order, that the state would be allowed through the officer, the arresting officer, for the officer to be able to testify, which he's got to, for the jury to even understand why the defendant's in custody. Since the arrest, basically, he was taken into custody prior to the search. The jury's got to understand why it's being done that way, so the court will allow the officer to testify in accordance with, I think, what would be agreeable to both sides. But and he'll have to be able to say, hey, found that out. In other words, he searched to determine, say, a computer, if he wants to ran the defendant, determined he probably won't use the word ran, but check the defendant, whatever, and found there was an outstanding warrant for the defendant's arrest. So the court would allow that, which apparently Mr. Chambers is agreeable to, and that would be the court's ruling on the motion to eliminate. The motion to eliminate would be granted only to the extent that the state would not be allowed to go into through the officer that it was a blue warrant, because then you're going to have to explain the blue warrant, and then that's going to bring in and make evident to the jury the defendant is on parole. So that would be the court's ruling.
Judge, the only other thing I know that we need to take up right now is I understand we picked a jury on the prior case. I assume we're going through that same procedure again, where we start in the 7th and at some point to do preliminary things and then go down to the central jury room. I just need to make sure that Mr. Evans is dressed out.
Well, I'm sure that Mr. Chambers will talk to the SO, the sheriff's office, and be sure that obviously the defendant, as they always are, when they're going to appear before a voir dire panel and then later a jury, the defendant will certainly not be in a jail uniform. He'll be dressed out. I think that's foregone. I've never seen one brought down in front of a panel before. My memory may not go back as many years as I've been in these trials, but I think it's standard. Just be sure they know it's a jury trial, Mr. Chambliss. Be sure they know the jury, that the defendant's going to be in front of a panel anyway, the first day. And he needs to be dressed out. I'll certainly take care of that.
Yes, sir. That's all the pretrial the defense would have at this time, Your Honor.
Okay, Mr. Chambliss, will you take care of being sure the SO has the defendant dressed out, not in a jail uniform Monday, because we will follow the same procedure. We'll go through and qualify a certain number Monday, then come back, qualify a certain number Tuesday, and then we come back, start the evidence Wednesday.
That I will make sure that my investigator lets the jail know that the defendant needs to be dressed in his street clothes, not in obviously a jumpsuit. Mr. Davidson had indicated to the court that he was only planning on filing his standard pretrial motions. Just so the court knows, I have not seen motions from Mr. Davidson on this case, but I have obviously seen his standard motions in many other cases. If those are the only motions that he files, I won't have any objection to those. But in the event that there is anything different, I would like the ability to reserve the right to bring that up prior to the start of trial.
That's understandable. Mr. Davidson, can you get since you said they are your standard pretrial motions, we're all familiar with those, could you go ahead and get your pretrial motions? What the court would order is, unless you tell me some good reason why you can't do it, court will order all your pretrial motions be filed today. Can you do that?
Yeah, I can e-file them today, Judge.
All right, that'll take care of that. That'll be Mr. Chambliss, all the pretrial motions he's dealing with, and then if for some reason he sees one we need to take up by Zoom before Monday, we can do that easily if you file them today.
And then the only other thing, Your Honor, and this is more just a preference of the court, you have a copy of the 404B And obviously, it's our standard policy for trials for us to go ahead and enroll the defendant typically before we even start the trial, because we are under the COVID restrictions and the way we're bouncing back and forth. Mr. Evans has a considerable number of priors. There's 11 that I am going to need my hand writing person to analyze, that I anticipate if we do reach punishment, we will put in all of 11 of those priors. And so just from a timing standpoint, when would the court, I guess, allow us to have access to the defendant in order to roll him?
Well, as far as the court's concerned, you could have access to the defendant to roll his prints today. But certainly need to ask Mr. Davidson. I doubt there's any objection to that. Unless Mr. Davidson has some objection I probably had never heard before. Certainly the state may have access, will have access today to have the defendant's fingerprints rolled, because in the event the defendant's found guilty, obviously the state apparently has some priors it wishes to put in punishment. So if that answers your question on that, the court's order will be that the defendant will be rolled. In other words, his fingerprints will be taken today, by an officer who then later would be testifying.
And I will, I'll make sure that my officer from the TPD is available today. And if he can't do it today, then as long as Mr. Davidson knows, I'll make sure it's done before Monday morning.
Well, that's sure well, I'm sure Mr. Davidson, you don't have any objection to that, do you, Mr. Davidson?
No, Your Honor.
All right, so get it done at the latest Friday of this week, Mr. Chandler. We won't do some last minute deal Monday, because we're going to be going through those jury selection procedures Mr. Davidson mentioned. As far as I know, Monday morning, we'll be operating under the same schedule we did before, where we'll go in Monday morning and Monday and qualify as many as we can off the panel Monday. They'll be instructed to come back Wednesday. Then we'll go down Tuesday, qualify as many as we can, and they'll instruct to come back Wednesday. And Wednesday, we'll have the attorneys, courts, and then the attorneys voir dire select a jury unless something goes haywire somewhere. Anything else?
I don't have anything else, Your Honor.
No, Your Honor.
All right, then.
Mr. Davis, can I,
Yeah.
is there any kind of way I could speak with you?
Yes, we'll talk later on a Zoom hearing, a Zoom meeting I have to set up with the jail, but we'll be talking soon.
All right, the court, then we're going to be in a recess. The defendant continued in custody. The court's ordering the state enroll the defendant's prints for purposes of proving up the priors in the event the defendant's found guilty. And then, unless there's something further, Mr. Davidson, I believe you were going to get, I guess, go ahead and get your pretrial motions filed today. You email them so Mr. Chambliss can look at them to see if there's anything else the court needs to take up. Otherwise, appears the way it stands right now that panel members will be coming in for hardships, a little like 8 or a little bit after 8, and then so we would need to have the defendant dressed out, be state defense, the court reporter, and everyone else required to be there Monday morning in the central jury room. Counsel, I don't know of anything else unless y'all have something else.
No, Your Honor.
I don't, Your Honor.
All right, we'll be in defendant's continued in custody under a $75,000 surety bond that's set on the indictment. And we'll be back in session in the central jury room for purposes of jury selection at 9 o'clock or thereabouts Monday morning. Recess till then unless one of you has something else.
I don't, Your Honor.
Be sure and get those pretrial motions filed today, Mr. Davidson, and you can go ahead and
Yes,
have the defendant roll. his Prince role, Mr. Chambers.
Yeah, we just need Mr. Fuentes now.
Your Honor, may I be excused? And Ms. Autry is going to handle the rest of the docket.
Yes, you may. Thank you, Mr. Chambers.
Thank you, Judge.
And a fine job she'll do. Okay, here we go.
All right, we're on the record by Zoom, and the following calls numbers. State's Counsel, Ms. Autry is present by Zoom. Mr. Davidson, Defense Counsel, is present by Zoom. The defendant, Levi Fuentes, is present by Zoom from the jail. The court's probation officer, Marcellus, is present by Zoom. And the court is calling calls numbers, appear to be 4 of them. Calls number 241-1692-20. State versus Levi Fuentes on an indictment charging unauthorized use of a motor vehicle. Calls number 241-1648-20. State versus Levi Fuentes on a charge indictment charging possession of a controlled substance less than a gram. Calls number 241-1647-20. State versus Levi Fuentes on an indictment charging evading arrest or detention with a motor vehicle with an enhancement paragraph. Calls number 241-1646-20. State versus Levi Fuentes on an indictment charging theft of property. Mr. Davidson, do you want to waive the reading of all 4 indictments and all the other formalities in all 4 cases?
Yes, Your Honor, his name is set forth correctly. We've had sufficient time to go over the indictments. It'll be pleas of guilty to all 4 indictments, and we have agreed recommendation on punishment.
All right, Mr. Fuentes, I need you to raise your right hand so I can swear you in. Do you solemnly swear the testimony you will give in the causes now on trial will be the truth, the whole truth, and nothing but the truth, and that all the plea documents in these cases, which are signed and then indicate they're sworn to, are being sworn to by you in each of these 4 cause numbers now, freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
All right, the court's going to need to go through these plea documents in all 4 cases, counsel. First of all, 241-1692-20 on the charge of unauthorized use of a motor vehicle. I need to be sure you understand all 4 indictments, Mr. Fuentes. The first one charges unauthorized use of a motor vehicle, a state jail felony. There's a plea agreement on that case for if you do plead guilty to unauthorized use of a motor vehicle, state jail felony. You, Mr. Davidson, and the state have agreed. The state's going to recommend to the court your sentence be assessed at 15 months in a state jail facility. That would be assessed with credit for time served. In cause number 241-1648-20, that's on an indictment charging possession of a controlled substance less than a gram alleged as a state jail felony. plea agreement on that case indicates if you plead guilty to the indictment charged possession of a controlled substance, and that cause number, state's going to recommend your sentence at 15 months in a state jail facility. Cause number 241-1647-20, that's on indictment charging evading arrest or detention with a motor vehicle. That indictment alleges a prior felony conviction in the 114th District Court back on the 9th day of March 2018, and that cause number 1140677-16 for an offense of assault, family violence against a household member impeding breath or circulation. That indictment and that cause number 241-1647-20, there's a plea agreement on it. If you enter a plea of guilty to the offense of evading arrest or detention with a motor vehicle, a third degree felony enhanced to a second degree, if you plead true to the prior, the state's recommending your sentence at 8 years in the Texas Department of Corrections Institutional Division with credit for time served. The last case, 241-1646-20, State versus Levi Fuentes, theft of property as alleged in the indictment. On that one, if you plead guilty to that indictment, the state is recommending your sentence at 15 months in a state jail facility. All 4 sentences will be taken in the same hearing, meaning that all 4 sentences assessed by the court following the plea agreements will run concurrent, meaning at the same time with credit for time served. Are these your plea agreements, Mr. Fuentes?
Yes, sir.
Are these the plea agreements, Mr. Davidson?
Yes, Your Honor.
Are these your recommendations, Ms. Altry?
They are, Your Honor.
All right, now, Mr. Fuentes, all 4 pleas are being taken at the same time, so all 4 sentences will run concurrent or at the same time with credit for time served. Need to ask you, first of all, if you've gone over with Mr. Davidson, your attorney, all the plea documents in all 4 of these cases and the indictments in all 4 cases, so you understand all the plea documents you've signed and now signed and sworn to in all 4 cases, as well as do you understand all the allegations and the charge in each indictment and each cause number and the full range of sentencing as well as your plea agreements?
Yes, Your Honor.
Do you still wish to proceed on your plea of guilty to the indictment in each one of these 4 cause numbers, requesting the court to follow the plea agreements? And this would be done without a jury. You have a plea paper in each case you sign, which gives up your right to a trial by jury. Do you understand all that?
Yes, Your Honor.
All right, I'm going to go through and just identify for the record, starting on the first case, and I'm only going to not do it on one case. That's just from the standpoint of identifying on the record your plea agreements. In 241-1692-20, on the indictment charge of unauthorized use of a motor vehicle, the plea agreement there appears to be if you plead guilty to that offense, which is a state jail felony, the state's recommending your sentence at 15 months in a state jail facility, which will be assessed with credit for time served. In cause number 241-1648-20, possession of a controlled substance less than a gram, that's another state jail felony. On that one, the state is also recommending the same sentence, 15 months in a state jail facility, again, would be assessed with credit for time served. And there'd be a $180 lab fee or to be paid to the Department of Public Safety for the analysis of the controlled substance. Is that your plea agreement on that one, Mr. Fuentes?
Yes, sir.
The next one, 241-1647-20, that's on the indictment charging evading arrest or detention with a motor vehicle. Evading arrest or detention with a motor vehicle, as alleged in the first paragraph of the indictment, is a 3rd degree felony carrying a sentencing range of not less than 2 no more than 20 years in the Texas, not less than 2 no more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. However, that indictment has an enhancement paragraph. The enhancement paragraph, as alleged in the indictment, the 2nd paragraph alleges prior felony conviction for assault, family violence against a family household member, impeding breath or circulation. If you plead true to those allegations of the prior, it'll enhance your sentencing range up to not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division. So on this one, evading arrest or detention with a motor vehicle, the state's recommending your sentence at 8 years in the Texas Department of Corrections Institutional Division. No restitutions in the case due. That would be assessed with credit for time served. Is that your plea agreement on that one, Mr. Fuentes?
Yes, Your Honor.
Cause number 241-1646-20. That's an indictment charging theft of property, another state jail felony on that one. If you plead guilty to the offense, theft of property is alleged in the indictment of state jail felony. The state's going to again recommend on that state jail felony your sentence at 15 months in a state jail facility. Your plea documents there indicate that there would be what we call a post sentence to be done in the event there is any restitution to be due. It would be ordered. Is that your plea agreement on that one, Mr. Fuentes?
Yes, Your Honor.
All right, Mr. Fuentes, on all four of these cases, you understand in all four cases you are waiving and giving up your right to a trial by jury, asking the court to just hear each of the four cases on your plea of guilty without a jury and follow the plea agreement. Is that correct?
Yes, Your Honor.
All right, I'm going to go, and you do understand all the allegations, the charge in each indictment, the full range of sentencing, and all the plea documents you've signed or sworn to in each cause number. Is that correct?
Yes, Your Honor.
Mr. Fuentes, down there, the first case up there, 1646-20, that theft of property. Down the right side, there's a signature on line above where it says defendant. Is that your signature?
Yes, sir.
It's also signed by your attorney. It's signed by Ms. Autry, assistant criminal district attorney. When you signed and swore to each one of these plea documents, you did go over each plea document and each cause number with your attorney, Mr. Don Davidson, where he explained all these plea documents to you and each cause number, where you understood the plea document when you signed and swore to it. Is that correct?
Yes, Your Honor.
All right, I'm going to go through and ask you some questions now. Of course, all these pleas are obviously be taken in the same hearing, so all four sentences assessed by the court following the plea agreements will run concurrent at the same time with credit for time served. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir. I have.
Do you understand everything you do in court today on all four of these cases?
Yes, Your Honor.
Have you been over the facts of each one of these four cases with your attorney, Mr. Davidson?
Yes, Your Honor.
Is he competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Autry?
No, Your Honor.
All right, court does know State's counsel signed her consent to approve the waiver of trial by jury in all four cases. The court does approve the waiver of trial by jury and all the other documents in all four cases signed and sworn to by the defendant. All right, now, Mr. Fuentes, you do understand the allegations and the charge against you in the indictment in each cause number. Is that correct?
Yes, Your Honor.
And you understand the full range of sentencing and your plea agreement and all your plea documents you signed and sworn to in each one of the four cause numbers. Is that correct?
Yes, Your Honor.
Do you have any questions for me about anything?
No, Your Honor.
All right, in cause number 241-1692-20, what is your plea today to the indictment charging you with unauthorized use of a motor vehicle, a state jail felony?
Guilty.
In cause number 241-1648-20, what is your plea today to the indictment in that cause number charging you with possession of a controlled substance less than a gram, a state jail felony?
Guilty.
In cause number 241-1647-20, on that indictment, which charges evading arrest or detention with a motor vehicle, I need to read the second paragraph to you, which is going, it's up on the screen. That's called an enhancement paragraph. I'm going to read it to you. I'm going to ask you whether or not your plea is true or not true. If you enter a plea of true to those allegations in that second paragraph up on the screen alleging a prior felony conviction, it will enhance or increase your sentencing range up to that of a second-degree felony, not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division, fined of up to $10,000. You understand all that?
Yes, Your Honor.
It's further, this is right up off the screen. It is further presented that prior to the commission of the charged offense, evading arrest or detention with a motor vehicle, that on the 9th day of March 2018 in cause number 1140677-16 in the 114th District Court of Smith County, Texas, It's alleged you were finally convicted of the felony offense of assault family violence against a household member, impeding breath or circulation. Are those allegations true or not true?
The true.
Are you entering your plea of true to these allegations in the enhancement paragraph of the indictment in this cause number freely, intelligently, knowingly, and voluntarily?
Yes, sir.
No one's threatened you in any way or promised you anything to get you to plead true. Is that correct?
No, sir.
Court does receive and accept your plea of true, and the court does find as true the allegations in the second paragraph of the indictment alleging prior felony conviction for the offense of assault, family violence, impeding breath or circulation, enhancing, increasing the sentencing range for the offense of evading arrest or detention with a motor vehicle in this indictment up to that of a second-degree felony, as reflected in the plea documents, not less than 2 years or more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. 241-1646-20, as the court's already said, that's an indictment charging theft of property, a state jail felony. Again, on this one, there's a plea agreement of 15 months in a state jail facility. So on each one of these indictments, Mr. Fuentes, you do understand all the allegations, the charge in each indictment, the full range of sentencing in each indictment, and all your plea documents and your plea agreement in each one of these 4 cause numbers. Is that correct?
Yes, Your Honor.
And you did go over each one of these plea documents and each one of these 4 cause numbers with your attorney, Mr. Don Davidson, present here on Zoom, where he explained all these plea documents and all 4 cases to you prior to the time you signed and swore to each one of the plea documents. Is that correct?
Yes, Your Honor.
All right, I'm going to go through now and take your pleas to the indictments in each one of these cause numbers. In cause number 241-1692-20, what is your plea today to the indictment charging you with unauthorized use of a motor vehicle as alleged in the indictment?
Guilty, Your Honor.
In cause number 241-1648-20, what is your plea today to the indictment in that cause number charging you with possession of controlled substance less than a gram of state jail felony?
Guilty.
In cause number 241-1647-20, what is your plea today to the indictment charging you with evading arrest or detention with a motor vehicle enhanced, increased up to a second-degree felony range, not less than 2 nor more than 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000? What's your plea to the indictment charging evading arrest or detention with a motor vehicle today?
Guilty, Your Honor.
In cause number 241-1646-20, what is your plea today to the indictment in that cause number charging you with theft of property, a state jail felony, as alleged in the indictment?
Guilty, Your Honor.
Are you entering your pleas of guilty to the indictments in each 4 cause numbers today because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything or coerced you in any way to plead guilty to any of these 4 indictments?
No, Your Honor.
Are you entering your plea of guilty to the indictment in each cause number today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment in each cause number?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment in any of these 4 cause numbers as a result of any type delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictments in all 4 cases. Receiving and accepting your pleas of guilty and finding all pleas of guilty to all 4 indictments were entered by you freely, intelligently, knowingly, and voluntarily. Court having received and accepted your pleas of guilty to the indictments in all 4 cause numbers, what do you have?
In each case, Your Honor, we would offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn to stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection.
With no objection, the court admits into evidence in each cause number, states exhibits 1, 2, 3, and 4. The court finding the defendant's waiver of his rights and execution of all of these documents and all 4 cause numbers were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in all 4 cause numbers was entered by the defendant to the indictment in all four cause numbers freely, intelligently, knowingly, and voluntarily. The court in all four cause numbers, based upon the defendant's plea of guilty to the offense alleged in the indictment in each of the four cause numbers, and the evidence presented and admitted into the record by the court in each of the four cause numbers, the court does find that the defendant's plea of guilty to the offense alleged in the indictment was entered freely, intelligently, knowingly, and voluntarily as alleged in the indictment, and the court does find the defendant guilty of the offense alleged in the indictment in each one of the four cause numbers. Moving to sentencing, what do you have, Ms. Alford?
We would offer states 4 an electronic copy of the written discovery in each case.
With no objection, Mr. Davidson.
No objection, Your Honor.
With no objection, State's Exhibit 4, all offense investigative reports and other documentary or other type evidence submitted into evidence in each one of the four cause numbers without objection. The court then, having received and accepted the defendant's pleas of guilty to the offense alleged in the indictment in each cause number, the court receiving and accepting the defendant's pleas of guilty to the indictment, finding each one was entered freely, intelligently, knowingly, and voluntarily, the court follows the plea agreements and the recommendations of the state in the plea agreements. And in cause number 241-1692-20, the court, having found the defendant guilty of the offense of unauthorized use of a motor vehicle, a state jail felony, follows the plea agreement, the recommendation of the state, assesses the sentence in the case at 15 months in a state jail facility, assessed with credit for time served. Cause number 241-1648-20, the court having received and accepted the defendant's plea of guilty, having found the defendant guilty of the offense alleged in the indictment, the court follows the plea agreement, assesses the sentence at 15 months in a state jail facility, assessed with credit for time served, $180 DPS lab fee ordered paid as part of the sentence. Cause number 241-1647-20, court receiving and accepting the defendant's plea of guilty to the indictment charging of evading arrest or detention with a motor vehicle, the court having received and accepted that plea of guilty, the court having found the defendant guilty of the offense.
What kind of work you do, I can imagine. I'm sorry.
What was that, Mr. Davidson? Did you say something, Mr. Davidson?
No, sir. I just said no objection.
Okay, all those documents or exhibits are admitted in with no objection. The court in cause number 241-1647-20, the court having received and accepted the defendant's plea of guilty to the offense of evading arrest or detention with a motor vehicle enhanced to a second-degree felony, the court follows the plea agreement and the recommendation of the state in cause number 241-1647-20, the court finding the defendant guilty of the offense of evading arrest or detention with a motor vehicle, third-degree felony enhanced to a second-degree felony. The court follows the plea agreement, the recommendation of the state, and assesses the sentence at 8 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served, no restitution to indicate its due. Cause number 241-1646-20, court having received and accepted the defendant's plea of guilty to the offense of theft of property, state jail felony as alleged in the indictment, the court follows the plea agreement, the recommendation of the state, and assesses the sentence in the case at 15 months in a state jail facility on the theft of property in 241-1646-20. A special condition of the sentence being that the court is assessing restitution in the amount determined to be due by post-sentence, Marcel. So we'll need a post-sentence on this one on restitution. And if restitution is determined to be due, it's ordered as part of the 15-month sentence in a state jail facility.
Your Honor, in regards to restitution, the vehicle was recovered.
Okay, so then there is no restitution, I take it, in cause number 241-1646-20. It was recovered in basically the same condition it was stolen in?
Yes, Your Honor.
All right, no restitution is indicated as due. Be the order of the court in all four cause numbers. I'm sure there's no legal reason to bore formal sentencing, correct, Mr. Davidson?
That's correct, Your Honor.
All right, in all four cause numbers, the court having found the defendant guilty of the offense alleged against it by the state in its indictment, the court having followed the plea agreements and recommendations of the state in each one of the four cause numbers, having assessed the sentence recommended by the state, agreed to by the defendant and his attorney. The court formally pronounced his sentence in all four cause numbers as follows: 241-1692-19, 15 months in a state jail facility. Cause number 241-1648-20, 15 months in a state jail facility. Cause number 241-1647-20, 15. On that one, that sentence for evading arrest or detention with a motor vehicle enhanced to a second-degree felony. And cause number 241-1647-20, the court again, following the plea agreement, assessed the sentence for evading arrest or detention with a motor vehicle at 8 years in the Texas Department of Corrections Institutional Division. In cause number 241-1646-20, the court is having found the defendant guilty of the offense alleged in the indictment, following again the plea agreement, assessed the sentence of 15 months in a state jail facility. All four sentences are assessed with credit for time served. All four sentences are ordered to run concurrent with each other at the same time, with credit for time served, with the court following the plea agreements in all four cases. Sentence is formally pronounced. Mr. Fuentes, I have from you and Mr. Davidson waivers of your right to appeal and waivers of your right to file a motion for new trial in each one of the four cause numbers. Those waivers waive your right to appeal and your right to file a motion for new trial in all four cause numbers. Do you understand that, Mr. Fuentes? Still with me? Do you understand, Mr. Fuentes, that you're waiving, giving up your right to appeal in all four cases? I guess I've lost him.
We
I
can't,
guess I've lost him, Mr. Davidson.
I
He's
can't,
on the screen, but I can't hear him now.
he's talking.
He is to someone. Just one more. Okay, let's see if we can get him hooked back up. Are you giving up your right to appeal and your right to file a motion for new trial in all four cases, Mr. Fuentes, according to the documents?
Yeah.
Yeah, if we could,
Yeah, just, all right. Mr. Fuentes, can you hear me, Mr. Fuentes? Yeah. Can you hear me? Are you waiving, giving up your right to appeal and waiving, giving up your right to file a motion for new trial according to these documents in all four cases, freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
All right, court receives and accepts the waiver of appeal. The court receives and accepts, approves the waiver of right to file a motion for new trial in all four cases. Mr. Don Davis has been your court-appointed attorney in all four cases. Are you satisfied with Mr. Don Davidson's legal representation in all four cases?
Hello?
Hello? I guess I've lost him again, Mr. Davidson.
yeah, he's our last in jail.
Yes,
Did
Your
you-
Honor.
did
Oh,
you-
there, now he's talking.
Here's my last question, Mr. Fuentes.
Yes, sir.
Are you satisfied with your court-appointed attorney, Mr. Don Davidson's legal representation of you in all four cases?
Yes, Your Honor.
All right, it'll be the order of court. You'll be continuing the custody of the sheriff until you can be transported to state jail facility in the Texas Department of Corrections Institutional Division to serve the sentences assessed by the court following the plea agreements, waivers of appeal accepted. Anything else, Mr. Davidson?
No, Your Honor.
We're in recess on all four cases. You don't have anything else, do you, Ms. Offer?
No, Your Honor.
Defendant's continued in custody on all four cases until he can be transported to the Texas Department of Corrections to serve the 8-year sentence assessed by the court and/or state jail facility to serve the sentences assessed by the court in all three of the state jail felonies. All sentences assessed with credit for time served are to run concurrent at the same time. Waivers of appeal are accepted. We're in recess.
And Your Honor, we've got two out of jail next, and I've got the paperwork, but I need to get it signed. Can we take a short recess?
We'll be in recess for 20 minutes.
Thank you.
Recess for 20 minutes.
Thank you, Your Honor.
So. Hello? Yes. What's his name? Brantley? Yeah, I'm his court-appointed attorney. Oh, yeah. Well, and I only take court-appointed cases, so I don't charge anybody anything, So yeah, but is this the best number to reach you at? Okay. Okay. Well, I'm actually waiting for Judge to come back on a Zoom hearing we're having right now. So let me call you back when I get a chance to look at some paperwork on him. Okay. Oh, and what's your name so I can put it in my contacts? Yvette. And are you a Brantley too? Okay, sounds good. Well, I'll call you back here soon. Yes, ma'am.
Mr. Davison, what county does Mr. Salinas live in?
He lives in Wood County, but he's been going to pretrial here.
Okay, okay.
And did you know what the agreement was?
4 years deferred adjudication.
It came up with 3.
Oh, 3 years? Okay.
That's correct, Marcella.
Okay.
We changed it to 3.
Okay. And Mr. Donald Davison, I know he lives in Wood County, but does any of his address fall in also Rains County?
Does
Like
it?
his specific residence fall in Rains County also, or is just Wood County?
Wood County.
Just Wood County.
Okay, okay, thank you.
I guess sometimes they meet up there, the 2 counties. Yeah, it's easier if we don't use headsets.
Dawn, you have a visitor?
Oh, hey, I was just calling you.
Sorry.
Okay, good deal. Oh, just have a seat. We're going to take care of him and then we're going to take care of you.
All right, thank you.
Yeah, I checked with Marcella and you're current. So we're good. So far, we're not interrupting anybody, so we're not using headsets. We're just going to try to do this over the Zoom. Shouldn't be too long. As soon as Judge gets on the bench, what they'll do is they'll see that I'm going to start with the indictment and then the papers that we've signed. we got? Huh? Oh, never mind. Okay, and just kind of scoot a little more toward this so they can hear us.
So I think we get ready to tap them.
We're ready.
We're on the record in cause number 241-1811-20, State versus Edward Salinas on indictment charging theft of firearm as alleged in the indictment. State's counsel is present. Defense counsel, Mr. Davidson, is present. With Mr. Davidson in the county law library by Zoom is the defendant, Edward Salinas. Mr. Davidson, you want to waive the Reagan formal presentation of the indictment charging theft of a firearm?
Yes, Your Honor, his name is set forth correctly. We've had sufficient time to go over the indictment. It'll be a plea of guilty. We have an agreed recommendation on punishment.
All right, Mr. Salinas, just remain seated where you are, but raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Salinas, have you gone over the indictment, which is up on the screen, charging you with theft of firearm as alleged in the indictment? Do you understand the allegations and the charge in the indictment?
Yes, Your Honor.
Do you understand that indictment alleging theft of a firearm? That's a state jail felony offense as alleged, carries a sentencing range of not less than 180 days, no more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. You understand all that?
Yes.
You're looking up there at the screen now, agreed punishment recommendation. Down the right side's a signature I can easily read, but I just need to ask you where it's signed Edward R. Salinas. Is that your signature, Mr. Salinas?
Yes, sir.
Plea documents are also signed by Ms. Altry, State's counsel, and Mr. Davidson, Fed's counsel. So you see there your agreed punishment recommendation. Your plea agreement is if you enter a plea of guilt for this state jail felony theft of firearm, Ms. Altry, State's attorney, is going to recommend your sentence at 3 years, deferred adjudicated probation, no restitutions indicated as due. Is that your plea agreement? Is that his plea agreement, Mr. Davidson?
It is, Your Honor.
Do you understand that to be your plea agreement, Mr. Salinas? 3 years deferred adjudicated probation?
Yes.
Is that your recommendation, Ms. Altry?
It is, Your Honor.
Of course, the court has the following plea documents also. These are all signed by the defendant or signed and sworn to by the defendant. So all signed by his attorney, all signed by state's attorney. An acknowledgement of admonishments, a waiver of trial by jury, a waiver of confrontation with witnesses, an agreement to stipulate testimonies, stipulation of evidence. States 2, agreement to stipulate testimony, form for a waiver of appeal, request to allow a waiver of the pre-sentence which is approved, trial court certification of the defendant's rights to appeal, and a certification from the defendant back to the court on advice he's received from his attorney on his rights to appeal. Did I swear in? Mr. Salinas, do you understand all the allegations on the charge in the indictment for theft of a firearm, a
Yes.
state jail felony? Do you understand the full range of sentencing as well as your plea agreement?
Yes, Your Honor.
All these plea documents you've signed or signed or sworn to. Did you go over each one of those plea documents with Mr. Davidson so you understood each one of the plea documents when you signed and swore to it? Do you understand all the plea papers?
Yes.
All right, I'm going to go through and ask you some questions now. You do wish to go forward on your plea of guilty to the indictment without a jury trial, is that correct? Can he hear me, Mr. Davis?
I think
Yes, Your Honor.
he said
Okay,
yes.
I'm sorry, I couldn't hear you. All right, first document's a plea document. If you enter a plea of guilty to the offense of theft of a firearm, state jail felony is alleged in the indictment. State's going to recommend your sentence at 3 years deferred adjudicated probation. Mr. Salinas, no restitution shown as indicated to be due. Is that the plea agreement, Mr. Davidson?
Yes, it is, Your Honor.
Is that your plea agreement, Mr. Salinas?
Yes, Your Honor.
Is that your recommendation, Ms. Autry? Is that your recommendation, Ms. Autry? Can you hear us? Oh, you're muted.
It is, Your Honor.
All right,
Sorry
thank
about that.
No, that's okay. In addition to the plea agreement, just to identify them for the record, I got an acknowledgement of admonishments with 7 admonishments. A waiver giving up the defendant's right to trial by jury. Mr. Salinas, you do understand you're waiving giving up your right to a jury, is that correct?
Yes, Your Honor.
Waiver of confrontation with the witnesses, agreement to stipulate testimony, stipulation of evidence, a written judicial confession to the allegations and the charge in the indictment, signed and sworn to by the defendant, an agreement to stipulate testimony, waiver of appeal, waiver of right to file a motion for new trial, waiver of the pre-sentence trial court certification of the defendant's rights to appeal, certification from the defendant back to the court on advice he received on his rights to appeal. Mr. Davidson, did I get him sworn in?
No, sir.
Raise your right hand, Mr. Salinas. Let me get your oath on the record. Do you solemnly swear the testimony you'll give and the cause now on trial will be the truth, the whole truth, and nothing but the truth, and that when you signed and swore to each one of these plea documents, you are swearing to the plea documents the truth thereof freely, intelligently, knowingly, and voluntarily? Is that correct?
Yes, Your Honor.
Your plea agreement tells the court if you do enter a plea of guilty to the offense alleged in the indictment, Ms. Alter, state's attorney is going to recommend your sentence at 3 years deferred adjudicating probation. You've got an acknowledgement of admonishments, gives you the full range of sentencing. Do you understand all the admonishments? There's 7 of them.
You put your hand. Do you understand?
Yes, sir.
Are you waiving giving up your right to a jury trial?
Yes, Your Honor.
Are you waiving confrontation with witnesses on the plea and agreeing to stipulate testimony?
Yes.
Do you understand up on the screen is a stipulation of evidence signed and now sworn to by you? Do you understand the stipulation of evidence is a written judicial confession under oath by you to the allegations and the charge in the indictment?
Yes, Your Honor.
Did you sign and swear to the stipulation of evidence of your own free will and sign it voluntarily?
Yes.
There's an agreement to stipulate the court approves stage 2. Then there's other waivers of a right to appeal, waiver of right to file a motion for new trial, another plea paper that is an agreement to stipulate testimony. Anyway, all these plea documents you signed and sworn to, Mr. Salinas, all signed by your attorney. Do you understand all these plea documents you've signed, Mr. Salinas?
Yes, sir.
Do you still wish to go forward on your plea of guilty to the indictment without a jury?
Yes.
All right, do you read, write, and understand English?
Yes.
Have you consumed any alcoholic beverage in the last 24 hours?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No.
Have you ever been in like a psychiatric hospital?
No.
Do you understand everything you're doing in court today?
Yes.
Have you been over everything you're doing in court today as well as the facts of the case with your attorney, Mr. Davidson?
Yes, sir.
Is he competent, Mr. Davidson?
He is, Your Honor.
Any evidence of incompetence, Ms. Autry?
No, Your Honor.
Will no state's counsel sign her consent to approve the waiver of trial by jury? Court approves the waiver of trial by jury, all the other waivers in the case and all the other plea documents in the case, signed or sworn to by the defendant, signed by his attorney, state's attorney. All right, do you have any questions for me about anything, Mr. Salinas?
No, sir.
All right, in calls number 24118-11-20, what is your plea today to the indictment charging you with theft of firearm, a state jail felony as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment freely,
Yes,
freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Anyone threaten you in any way or promise you anything to get you to plead guilty?
No, Your Honor.
I'm sorry?
No, Your Honor.
All right. Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense of theft of a firearm as alleged in the indictment?
Yes, Your Honor.
Are you pleading guilty as a result of any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency? Yeah, I know. I used to sit at the state's table in the 114th and wonder what that question was all about when I was a prosecutor, not a judge. I just have to be sure you do understand that you're telling me you're entering your plea of guilty today to the indictment is that you're not pleading guilty because you have any delusion in your mind. Is that correct?
Yes.
Okay. All right. The court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Officer?
We would offer States 1, the plea packet with signed waivers and admonishments, States 2, the signed and sworn to stipulation of evidence, as well as States 3, the discovery compliance documents.
No objection.
With no objection, States 1, 2, and 3 are all admitted into evidence. The court finding of the defendant's plea of guilty entered to the indictment charging you with theft of a firearm, state jail felony was entered by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the evidence in the record on the defendant's plea of guilty to the offense charged in the indictment is fully sufficient to support the defendant's plea of guilty to the indictment. However, the court does withhold the finding of guilt to the defendant. Move to sentencing, Ms. Autry.
We would offer States 4, an electronic copy of the written discovery in this case.
No objection.
Stage 4, all offense investigative reports admitted into evidence with no objection. The court then in this cause number based upon the defendant's plea of guilty to the offense of theft of a firearm, state jail felony as alleged in the indictment. The evidence presented and admitted into the record by the court. The court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense of theft of a firearm as alleged in the indictment. However, the court does withhold the finding of guilt as to the defendant, follows the state's recommendation, and the plea agreement says in the sentence at 3 years deferred adjudicated probation, no fines assessed, court costs ordered paid. Any restitution due?
No, Your Honor.
No restitutions indicated due. Legal reason for formal sentencing?
No, Your Honor.
Finding none, the court formally pronounced that the sentence finds the evidence in the case fully sufficient to support the defendant's plea of guilty to the offense of theft of a firearm, state jail felony as alleged in the indictment. However, the court does withhold the finding of guilt, follows the plea agreement, the recommendation of the state, sets the sentence in the case at 3 years deferred adjudicated probation, no fines assessed, court costs ordered paid, no restitutions indicated as due. Sentence is formally pronounced. Waiver of appeal is accepted, signed by the defendant and his attorney. Waiver of right to file a motion for new trials accepted and approved by the court. Mr. Salinas, the court's probation officer is on this Zoom, Marcella. I'm gonna need to explain to you, first of all, as of today, you're on the court's deferred adjudicated probation. You'll have about 70 or so terms and conditions of your deferred adjudicated probation. Marcella's going to talk to you about what you need to do when you leave the law library down there. But if you serve out the 3 years deferred adjudicated probation, you do not violate any of the terms and conditions of your deferred adjudicated probation. At the end of the term, you're on deferred for, state will dismiss the indictment. You will not have a final conviction on your record for this offense. You understand that?
Yes, Your Honor.
The other side of the road is if any time during the next 3 years you violate any one or more conditions of your deferred adjudicated probation, the state will file what's called a motion to adjudicate, alleging violations by you of your deferred adjudicated probation. That would cause a no bond warrant to be issued by the judge of the court for your arrest. Then there would be a hearing held before the judge, not a jury. If the judge determined the evidence in the record on the state's motion to adjudicate, what's called, the judge would grant the state's motion to adjudicate, go back and find you guilty of the offense of theft of a firearm, a third-degree felony, and then because you were on deferred, the judge can assess you a sentence up to 10 years in the Texas Department of Corrections, fine of up to $10,000. You understand all that?
It's a state jail, Your Honor.
What'd I say?
You said a third degree.
Well, I made a mistake. I meant a state jail. It's a state jail. So your sentence could be assessed up to 2 years in a state jail facility, fine of up to $10,000. Do you understand that?
Yes, Your Honor.
All right. Thanks for catching that, Mr. Davidson.
Yes.
All right, Marcel, would you go ahead and go over with him what he needs to do when he leaves the law library where he is with Mr. Davidson?
Yes, Your Honor. Mr. Salinas, immediately report to the Smith County Probation Department. When you get to the probation department, sign in new from court. Our intake officer will get you from the lobby and you'll be assigned a supervision officer today.
All right, now that's real important, Mr. Salinas, because your number one term and condition of your deferred adjudicated probation is to report directly to the probation department, as Marcella has said, immediately after this plea. So you appear to be in the county law library with Mr. Davidson, so you're probably within 15 minutes, you should be at the probation department. You do know where it is that correct?
Yes. Yes, Your Honor.
When you get there, your probation officer will be waiting for you. Then he or she'll go over all your terms and conditions of your deferred adjudicated probation. They're going to ask you if you understand each one. Don't just sit there and say yes, 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 and not have any idea what the term requires. Because if they see what they believe to be a violation of a term, they'll file with the court a request for a no bond warrant for you, a violation report. So listen closely when they go over each term and condition. If you don't really understand what the condition is, tell them you don't understand it and they'll go back over and explain it to you, okay?
Yes, Your Honor.
All right, if there's nothing further, we'll be in recess. The defendant ordered to report directly to the probation department as term and condition of his deferred to meet with his supervising probation officer. Are you satisfied with the legal representation of you provided by Mr. Davidson, if I hadn't already asked you?
Yes, Your Honor.
Anything else, Mr. Davidson?
No, just that I'm going to have him wait here and then take him upstairs so he can get his fingerprints done, and then we'll get him over to probation.
No, that's a good plan. You have anything else, Ms. Autry?
No, Your Honor.
Anything else, Marcella?
Yes, Your Honor. He resides in Wood County and he will be ordered to report to Smith County, Your Honor.
He needs to report and be supervised. There's no difference in Wood County and Smith County. So he'll be supervised and his probation will remain here in Smith County. There's no need to transfer supervision up to Wood County. You can get to Wood County faster than you can a lot of places in South Tyler. So he'll be supervised up in Wood County. He'll be supervised here in Smith County, not in Wood County, Marcella.
Yes, Your Honor.
All right, we're in recess.
Thank you, Your Honor.
Over there. Let's switch out. Let's see it right there.
Hello.
Oh, dang it. We're on the record in calls number 24104 20-18 State versus Ayanna Smith. Ayanna, Ayanna Smith. This is a motion for early termination of deferred adjudicated probation. Filed by Mr. Davidson, her attorney is present by Zoom also. State's counsel, Ms. Autry is present. Go ahead on the court takes judicial notice of the file, all the documents in the file. Would note the original offense was abandoning or endangering a child.
And it was kind of unusual, Judge. It's one I hadn't seen before.
Well, if it's one you hadn't seen before, it's probably going to take a day to explain it. So let me look back at the indictment just a minute.
It just says with intent to return.
Abandoning a dangerous child, intent to return, state jail felony.
Your Honor, if I may, I had an opportunity to go over what the original offense was. She had left her 4-year-old child at home for approximately an hour while herself and her partner went to go get prescription medication for their dog. The child was outside on the sidewalk crying in approximately 50-degree temperature. And when the neighbor saw the child, they searched the home. Nobody was there. When officers were there is when mom, Miss Smith, and her partner showed up. And at that point, mom and her partner were both arrested for the abandoning and endangering with intent to return.
How old was the child?
I believe the child was 4 at the time, Your Honor.
Yeah, she's 8 years old now.
8 years old. Okay, being 8 years old, are you saying that the defendant and her partner, whoever it was, are you saying that she left her 4-year-old child outside? And
No, she was sleeping.
Okay.
She was
that's what
sleep. Yes, the child was sleeping when Miss Smith and her partner left, but the child did get outside of the apartment, was sitting on the sidewalk and crying, which is why the neighbor called the police, and that's why she has the charge that she has.
Well, I understand that. All right, so I've got it right. The facts that show that the defendant, Ms. Smith, left her 4-year-old child in the house asleep.
Correct.
She leaves with her boyfriend or whoever it was to go get something. And then apparently, probably someone saw the child wandering around outside unattended and called the police. The police go out there and then they show back up. Is that it?
That's correct, Your Honor.
That's a good way to get a little child killed. That's a really good way to get a little child killed.
Yeah.
A little child wandering around like that, obviously somebody could easily pick up the child, kidnap the child. Some dog could tear the child in half. That is absurd, ridiculous conduct. Totally irresponsible. Absolutely, totally irresponsible. It was going to have to be, I'm going to tell you what, there's going to have to really be a good reason for me to grant early termination in this case, Mr. Davidson. Leaving a little 4-year-old child asleep on a bed and then just leaving them unattended and they end up wandering around outside and the police find them, that is abysmal conduct. So you want to make an argument for early termination on this one, go ahead.
Well, if I can make two points besides what's in the motion. And number one is that I also represented Ms. Smith on her CPS case, which parallel tracked this. And she has successfully completed everything that CPS has asked her to do. In fact, they have gone ahead and dismissed that case because, and she keeps her parental rights to her daughter and is in constant contact with her. The daughter now lives with her mother in Little Rock, and that was by agreement with CPS. And so she has her full parental rights because she successfully completed all of the tasks that CPS put in front of her. And the other thing was that she's, if I could have Marcella just report regarding her status now on what she's done on the criminal side for her probation.
Go ahead, Marcella.
Your Honor, Ms. Smith is in compliance with her conditions of probation. She's reported to her officer as directed. She's completed the life skills class. She's completed the parenting classes. She's completed community service hours and is current on her financial obligations to Smith County, Your Honor.
And I can tell you, Judge, based on those two things, that I've had a significant contact with Ms. Smith over the years since this happened. She deeply regrets what happened and is thankful every day that her daughter is alive and well and safe, and that she has a good relationship with her and the rest of the family. The reason we're asking for the early termination, and without going into long details, and I could get Marcella to testify about some of this because I know it's in her file. Ms. Smith has had certain opportunities to be closer to the child and the family in Little Rock, work-wise and otherwise, and by early terminating, it would give her an opportunity to get back up to Arkansas and take care of her business. What's that?
Mr. Davidson, go back over Marcella, you can, might be, if you can, for the court. Give me that update, Marcella, or if you're aware of what Mr. Davidson's talking about. I'm trying to understand. Now, the child's up in Arkansas.
With the defendant's mother, Your Honor.
The child is in Arkansas with the defendant's mother. I'm sure that Mr. Davidson, do I understand that the defendant's mother has custody of the child from the CPS proceedings?
Correct. And she has joint custody with the mother. And there's another daughter that she has that's also there too. In Little Rock.
Okay, how old's the other daughter?
She's 5 years old. So you've got the 8-year-old and the 5-year-old.
All right, the little girl who was alleged in this offense that she pled guilty to and received deferred. Now, how old's that child now?
I'm sorry, she's 7 years old now.
All right. So are there two little girls now where they live with her mother now?
In Little Rock, correct.
In Little Rock.
And I think I attached a statement to the motion from Ms. Smith, I believe, explaining what it would mean for her to be able to have the early termination and why it would help her, not only her, but also her daughters and her mother, and give her more opportunities to be able to reconnect with them.
Okay, what is the status, Mr. Davidson, now of is the Child Protective Services still have jurisdiction in the case?
No, sir. They have dismissed their case. She has fully complied with everything that CPS told her to do, and so she's done with CPS. And the way they left it was she's a managing conservator with her mother over her daughter.
All right, so that was going to be my next question. You just answered.
Your Honor, if I may, I actually have the final order pulled up from CPS right now. Tawana White, who is Miss Smith's mother, is the one who was appointed permanent managing conservator. And then Miss Smith was appointed possessory conservator of the child. So she wasn't terminated and she does get rights to the child, but permanent managing conservator of this child is Miss Smith's mom.
Okay, all right. Thank you. That certainly bears on what was going to be the court's decision. So,
you're welcome.
As a result of the CPS proceedings, now her mother, who lives obviously up in Arkansas, her mother is the managing conservator of the child, correct?
Correct.
All right. Let me read this statement of the defendant. All right, I've reviewed the statement of the defendant in the case. Considering what the court now understands about the situation with this officer pulling the order up, and what Mr. Davidson has said, but now the court understands from the CPS proceedings that the mother of this defendant, young Smith, the mother is the managing conservator of the child who was the victim of the offense in this case, where the charge of abandoning or endangering a child. And so the court, now having the full picture, and I appreciate State Defense Counsel hesitant, probably would not have granted this as it stood, but now understanding that the mother is through the CPS proceedings, the mother's managing conservatorship, as is the managing conservator of the child. She lives in Arkansas. Considering now everything the court has noticed, if there's nothing further from State Defense Counsel, the court is going to grant the motion for early termination of deferred adjudicated probation. Now understanding the full picture, appears to the court the purposes of the deferred adjudicated probation have been met. The defendants followed all the terms and conditions. The children, or the two girls, are up in the custody as managing conservatorship of her mother from the CPS proceedings. So court satisfied that the ends of justice certainly would support in this particular case, the court granting the motion for early termination of deferred adjudicated probation. Ms. Smith, I hope you realize, and I think at this point you do from what the record reflects, how fortunate you are that nothing happened to your little girl. Do you understand that? I think you understand it, but this could have been a totally horrendous situation. You could have lost, and I think you realize it now, you could have lost your little girl, one of your little girls, by leaving her alone and unattended. Apparently, the deferred adjudicated probation the goals have been met. Court finds that from the record, considering the CPS proceedings. So, Ms. Smith, I'm going to grant the state's motion for early termination of the deferred adjudicated probation. I'm going to sign an order that your attorney, and I've also reviewed your statement, Ms. Smith, attached. Also, I'm signing the order terminating deferred adjudicated probation, finding the defendant has fully complied with all the terms and conditions of the deferred adjudicated probation, understanding now the CPS intervention in the case and the orders in place from CPS, where the defendant's mother is managing conservator of the child. They live up in Arkansas. The court's granting a motion for early termination, finding it is in the best interest of justice, and signing the order terminating deferred adjudicated probation. Anything else, counsel?
Not
No.
from the state, Your Honor.
Thank you, Your Honor. Nothing further.
All right, Ms. Smith, good luck to you. Take care of those girls.
I will. Thank you.
All right, we're in